Thank you for joining me. I'm Cali Lichter, and this is On the Docket, a weekly recap of crime and court in and around the state of Michigan. This week, new beginnings, new appeals, and new endings, starting with a new police chief in Grand Rapids. And a Muskegon County serial killer is asking the judge for another chance. Plus, a notorious Northern Shores child abuse case lost its appeal. All that and more is On the Docket. A story that we brought you last episode rapidly developed over the course of a few days. Just under a week after we met the candidates for the next Grand Rapids police chief, they chose a candidate. Interim Chief Joseph Trigg was chosen as the next chief to lead the department, and a week later, he was sworn in. At his swearing-in ceremony, multiple city leaders spoke about how Trigg will be a great leader for the community, and Trigg affirmed his commitment to integrity, accountability, and compassion. Let's start with a little bit of what City Manager Mark Washington had to say.
It became abundantly clear in the process that we had to look no further than Chief Trigg. And it was because he not only had the respect of the police department, but also the community, that it was clear that he was indeed the right person for the right time for this role. It's interesting as we celebrate now over 175 years of incorporation as a city, being founded in 1850. The Grand Rapids Police Department was formally founded in 1871, if history serves me correct. And what's instructive about that is that the community was here before the police department was here, which tells me that there cannot be a community without the police department, and there cannot be a police department without a community. And we need a leader of this department that's able not just to police our community, but to police with our community. And Chief Trigg has proven that he is that person. I want to thank him again for stepping up in what will be tonight his second swearing in, the first as an officer 25 years ago, but now as our chief law enforcement officer. And I want to thank his family, his wife and his two children, who are also members of both his relational family, but also this family of civil servants in the city of Grand Rapids. Thank you for your sacrifice, and thank you to all the men and women of the police department who are here tonight, those that could not be here who are serving, and of course, the community in which we're entrusted to serve as public servants. I look forward to the many days of positive improvement in safety as well as community relations that lies ahead of us. I am not misguided that there won't be days that we will be challenged as a community, but I believe, I hope that we will be able to work with Chief Trigg and get through whatever those times are ahead of us together.
We also heard from Mayor David LeGrand, who spoke about the importance of being connected to the community as the chief and advised Trigg to take the job seriously and do it for as long as he can.
The second thing I want to say, and I want to be real a minute, and I want to be frank. We need you to do this job as long as you can do this job, because it is a weight, and it is going to wear you down, and it is something that you are going to have to carry, and you are going to have to do as long as you can do it. But what I always say about people who serve in the military is when they are done with their tour, you say one thing to them: thank you. So I hope you do this job long. I hope you do it well. But I also hope that you do it only as long as you can, because this is a real weight that you're going to be carrying. This is a real responsibility, and it doesn't always come with praise. It comes with strain and stress and finger pointing and false accusations and people impugning your motives and impugning your character, and you know all this. But I want you to know that we know that you are stepping up to this role, but do it for as long as you can. Not forever, as long as you can. The third thing I want to say to you is this: we are proud of you. We know who you are. You didn't get this job because we did a bench press test, although you probably would have got the job among the 4 qualified. We didn't give you this job because we looked at a resume. The city manager made this decision with input from all of us in this community because we know who you are. And we want you to keep being who you are because we love you and we are proud of you. And we are here with you for this journey.
It was then Trigg's turn to take the oath of office. A big part of his career is his journey, something we spoke about together when he was chosen as the interim chief early in the spring.
I want to make sure our community is taken care of, and I know they trust that I'm going to do what's right. I have values, I have integrity, and accountability is a big piece of that. I have no problem holding our men and women accountable because I know I do it with love. Something that, as I said, I have Mr. and Mrs. Kosminski here today. Thank you for coming, and Kaz's big sister, Kristen. And like I said a long time ago, I would never, when I did the eulogy, that I would dedicate my life to honoring Kaz and his sacrifice. And when I get dressed, like I said, that's why I want the uniform to look nice, and that's why I want the shoes to look nice, and that's why I want our men and women to go out there and conduct themselves in a professional manner because of what this job means. And last thing I want is his legacy being tarnished by something stupid our men and women did. They're going to make mistakes because they're human, but we have an accountability system in place to hopefully address that. And if there's a way we can get better, that only helps us as an agency, and I'm all for it. Mentors. I had so many mentors that looked out for me. I don't want to name any names because I'll forget somebody and I'll feel bad about it. But I was one that put my head down and just work hard. And next thing you know, I had a mentor telling me, hey, take this next challenge. And you know, maybe it seems uninspiring or whatever, but that's just me. That's how I go about it. The rank, the pay, whatever, it didn't matter to me. It's just, it was a role. This job, if you do it right, has a lot of purpose, a lot of worth to it. You feel good helping somebody, whether it's helping a friend with a small task or helping the citizens of our city and taking pride in it, because there's a lot of people in our city that come from some tough situations like I came from, and you know, it doesn't take anything to be kind. And I know it's kind of a saying, but it's true. It costs nothing. So that's always been important to me. Who we are as an agency, or who I want to be, professional first and foremost. Like I said, my drive comes from somewhere deep because I've lost somebody in this profession, and I believe in what it's supposed to stand for, like I said. So I want to make sure we're always serving with integrity and honor. And we are special people, right? And you know, to do this job, to run towards danger and put your life on the line like Kaz did so many years ago for a family he didn't even know. I want to be compassionate, right? So it's important. Like I said, people are dealing with a lot of things that are unfortunate. Some situations they didn't ask to be in those positions, but they are, and the last thing they need is judgment from us.
Trigg will be the 16th chief to lead the department and the second African-American chief in GRPD history, after Eric Payne, also a GRPD veteran, was chosen to lead the department in the late 2010s. And next on the docket, we're going to Muskegon County, where a very high-profile case is getting renewed attention. Why convicted serial killer Jeffrey Willis is asking for a sentence to be vacated next. Now to Muskegon, where we look into the appeal of sorts of a Muskegon County serial killer who is asking for his sentence to be vacated. Jeffrey Willis was convicted twice for the deaths of Rebecca Bletch and Jessica Hiringa in the early 2010s. Willis was sentenced to 2 life sentences. He's back in the circuit court asking for a judge to question his sentence after he's exhausted his standard appeals all the way to the Michigan Supreme Court. His attorney says that new things have come to light, including ineffective counsel, and that should grant him a new trial. First, a quick overview of his motion for relief hearing. A Muskegon County courtroom was packed today with supporters of Rebecca Blech and Jessica Hieringa, some with shirts that read guilty. But his attorney argued Jeffrey Willis may not have deserved the conviction.
Once a challenge of this magnitude is raised to the ballistics evidence, it calls everything else into question.
Willis was found guilty 8 years ago and received 2 life sentences for the murders. Blech was out for a jog when she was shot and killed in 2014. Hieringa, a young mother, was last seen at a gas station in Norton Shores in 2013. Willis was convicted of her disappearance and death, even though her body was never found.
Count 1, open murder, guilty of first-degree murder, guilty of first-degree premeditated and first-degree felony murder. Count 2, kidnapping, guilty.
Willis is back after several failed appeals. This effort to challenge his conviction, not a standard appeal, had Willis's attorney bringing up several claims that there was discrepancy with the missing bullet, fabrication claims against law enforcement and prosecution, and that Willis's trial counsel and appellate counsel were ineffective.
And would it make a different outcome on appeal? I think there's a good chance that it would.
Which the prosecution countered, saying there was a lack of prejudice, a typo in the agency name was testified to and rectified already, and that the defense fails to show that any evidence is new or material.
And looking even at what the defense has provided shows that this was not this nefarious, we're going to tamper with evidence and plant things and try to make up evidence.
Judge Matthew Casel says he is taking the case under advisement and said he would issue a written opinion in around 56 days. Now let's dive into the hearing. We have the full thing available on our website and on demand right now, 13onyourside.com, and we don't have enough time to play the full almost hour hearing right now. I'll play for you the main arguments of both sides, starting with the defense and ending with the prosecution, so you can hear what they're hoping will get their side a win.
We raise a lot of issues. Okay. They principally can be summarized in 2 parts: ineffective assistance of trial counsel and prosecutor misconduct, both surrounding the ballistics evidence. And I can summarize that. It's really sort of an easy issue when you boil all of the facts down, all of the timelines in the exhibits. And these are the central facts, crucial to our case. Mrs. Blech was murdered. She was shot in the head. She was taken to autopsy. Dr. Shattuck, who was the forensic pathologist, testified that, or she didn't testify, but she found 3 entrance wounds, not including the keyhole wound, but only 2 bullets were retrieved and some fragments. Those bullets were given to Detective Harris, who witnessed the autopsy. He says he testified that there were only 2 bullets taken. So there was 1 entrance wound and no bullet to account for that. So where was the 3rd bullet? So the 2 bullets were taken to the Michigan State Police Lab, and that would be where Lieutenant Crump examined them. And the records show, our exhibits show, that he only received 2 bullets on July the 1st. That would be container 15, containing bullets 15A and 15B. He later says that at trial that he received the 3rd bullet, which would be bullet 17, in a separate container on July the 1st also. But that is a false statement, because as our exhibit F shows, he did not even receive container 17 until July 8th of 2014. So the question in all of this is, where did the 3rd bullet come from? And it's our contention that only after the prosecutor and the police rifled through Mr. Willis's papers at the jail, his confidential attorney notes, that were intended for his attorney, did they discover that they had a problem with the ballistics. Namely, 1 bullet was missing and couldn't be accounted for. And that's when they had to go back and correct the records to make sure that the 3 bullets were accounted for from the outset. And that's the substance of our argument, Your Honor, and that implicates both ineffective assistance of counsel on the part of Attorney Johnson, because he didn't get the submission reports and the return receipts, which would have corroborated everything that Mr. Willis is saying and has been contending about the ballistics report since the outset. He didn't do that, and it changed, without investigating the true nature of the ballistics, which Mr. Willis and his first attorney had devised as a strategy. They were going to focus on the ballistics evidence and the gaps in the evidence, that without doing that, Mr. Johnson changed the strategy to one of Kevin did it, and meaning his cousin Kevin Bloom. So that's the essence of our argument, Your Honor, and I think that at the very least what our submissions have shown in our exhibits, that when Attorney Justian called this clerical error, and when Lieutenant Crump and DJ Hilson, Prosecutor Hilson at trial, said there was a clerical error in the designation of the originating police agency, and when Ms. Bloomquist says it was a typo, that's completely false. It's a complete misrepresentation of everything that happened, because our exhibits show that continually throughout the examination process of the bullets, it was clear that bullet 17 was designated as having come from the police department and not the sheriff's department. So as we contended in our motion, that somehow they just came up with a 3rd bullet to correct what they believed to be were the gaps in the ballistics evidence. Even when you look at the bullets, you can see that bullet 15A and 15B look like they're bright and shiny. Bullet 17 is old and tattered. So what that means, Your Honor, is that there is a substantial basis to believe that Attorney Johnson performed deficiently, and that it calls into question the certitude of the prosecution's case, and that certainly it raises suspicions that the prosecution and the police were tampering with the ballistics evidence, trying to fill in gaps that they recognized after the fact existed, and that would call into question the integrity of the entire trial, both trials, actually. So that is the substance of our argument, Your Honor.
Like I said in the previous video, the defense is arguing that there was discrepancy with a missing bullet, fabrication claims against law enforcement and prosecution, and that Willis's trial counsel and appellate counsel were ineffective. Their argument is that these things could lead a new set of jurors to a different outcome. And that's what needs to be asked during a hearing like this. Is the evidence substantial enough to cast doubt in a juror to produce a different outcome in the end? So in this case, a not guilty verdict or a hung jury. And that's for Judge Casel to decide. Now to the prosecution, who is rebutting everything the defense claimed against them.
I think I'll start from where the court began, which is what we're here for. We're here for a 6500 motion, and as the court's well aware, the defendant bears the burden of showing entitlement to relief under this rule. This is not a full appeal. This is not a direct appeal. He's already exhausted those. He's had his appeal to the Court of Appeals. He had a standard 4 brief at the Court of Appeals. He's gone to the Supreme Court. He's had somewhat of a federal habeas review, which was dismissed without prejudice, but he's had his appeal. These are collateral motions. They are not the main event, and that's People v. Reed in our brief. And so with that, there's a much narrower scope that the court's to look at these, and it's not to look at these with a de novo review. It's to look at them with a narrow lens. And it's the people's position that the defendant has not established good cause or actual prejudice, and he hasn't established that there's newly discovered evidence under the second prong of 6500, 6.508. So with that, I'm going to get into the further arguments, but I really want to address this claim that's been made here today in oral arguments that I've somehow falsified what I've put in my briefs, that my office has falsified what's been put in the briefs. And yes, I stand by that there was a typo, and that's what was testified to by the lieutenant. That's what was presented, and looking even at what the defense has provided shows that this was not this nefarious, we're going to tamper with evidence and plant things and try to make up evidence. Looking at Exhibit E, Exhibit F, submission report 7 attached to the defendant's brief. It says, yes, I'll say, it does say MUPD with the designation. But if you look closer without just taking this as, oh, this is falsified, look at the submitting agency. Look at the primary agency, Muskegon County Sheriff's Department. Investigating officer, submitting officer, members of the Muskegon County Sheriff's Department. Going to the next one, the following exhibit in the defendant's brief. There's also that MUPD designation, which would be the Muskegon Police Department. But again, looking at the investigating officer, submitting officer, Chad Peterson of the Muskegon County Sheriff's Department. I apologize, I'm going to belabor the point here a little bit. But again, defendant's exhibit, I believe. This is, again, it's a transfer date showing a summary that shows it was returned to Officer Brian Harris of the Muskegon County Sheriff's Department. And again, it does have that MUPD designation. And it's signed by Brian Harris of the Muskegon County Sheriff's Department. Next one. Again, it's the summary, returned to Officer Chad Peterson of the Muskegon County Sheriff's Department. And again, MUPD designation. Unfortunately, Your Honor, this is a 2-letter typo, essentially, out of these 4 letters, that happened at the beginning of submitting the evidence. And that MUPD designation was put on subsequent documentation. This was testified to by Lieutenant Crump. This was rectified. This is not what is being portrayed to the court. And it's not what was testified to, it's not what the evidence showed. It's also, importantly, not what the Court of Appeals found. And I think that's important when we're looking at this from the context of what sort of motion is before the court. This is not material. This doesn't show prejudice. This hasn't been shown that there'd be a different result for the trial or trials of this matter. And so for that, I think that burden hasn't been shown specifically on the ballistics. And Your Honor, I guess I'll pause here on the ballistics if the court has questions for me on that. Your Honor. So with that, I don't have an independent recollection of if that was testified to at the trial or not. But remember, if we're talking about ineffective assistance of trial counsel and ineffective assistance of appellate counsel, you have to show deficient performance and actual prejudice, and that would have a different result. And I think the court, in your questioning of opposing counsel, has really gotten down deep into that second prong, is what is the prejudice? Because we have the items 15 that aren't subject to the same submission argument. And in fact, if Mr. Johnson were to bring that up, then that would highlight that, well, okay, if there's some issue with 17, we have 15A and B. And so I think that really undercuts any claim that this was deficient performance by Mr. Johnson. But it's not just Mr. Johnson we have to look at for purposes of today's hearing. It's almost sort of like a ineffective assistance of counsel within ineffective assistance of counsel claim. So Ms. Rappa, the appellate attorney, would have to be deficient in her performance on appeal by showing that Mr. Johnson prejudiced Mr. Willis's case. And I think when you look at the ample evidence in this case against Mr. Willis and I say this case, I mean these cases, when I'm saying that, if you look at the ample evidence against Mr. Willis in these cases, there is no showing of prejudice for his appellate attorney winnowing out a weaker argument, especially in light of the other ballistics evidence that there is no challenge to here on the 6500 motion. And it's fair for her to use that appellate strategy to choose stronger arguments. So I don't think under the 6500 chapter that there's entitlement to relief on that. And that wouldn't be good cause. I guess just to put a real fine point on it, there wouldn't be good cause for the court to go any further on this motion because he cannot show that. So, Your Honor, I apologize. I was going to go into the other arguments, if that's all right.
I'm sorry, Ms. Bloom, I should have asked you.
No, that's okay. Well, and really, Your Honor, I think I would just be echoing myself a little bit on these other arguments as it relates to claims that were not brought on appeal, that defense is now saying should have been brought on appeal. And the appellate advocacy that Mr. Willis received was extensive. It was a lengthy brief. I've attached the briefing from the appellate counsel to the motions, his standard 4 brief. And, Your Honor, there are cases out there that say that you can absolutely consider what's been raised in a standard 4 brief for purposes of addressing if something's been raised and properly argued on appeal. And so looking at the totality of what was presented to the court and it's in his direct appeal and what he did not present in his direct appeal, what now is presented has not been established as good cause for failure to raise any of those claims on appeal. And I really want the court to focus on both prongs. The second prong is prejudice. And, Your Honor, with this case, with these cases, with the evidence presented, he cannot demonstrate prejudice from any of these issues, let alone one of them, to warrant any further review from the court, and he's not entitled to any evidentiary hearing to further those claims.
Like I said earlier, the prosecution said there was a lack of prejudice, a typo in the agency name was testified to during the original trial and it was rectified already, and that the defense fails to show that any evidence is new or material. The argument is that all of this isn't relevant, and if it was, it would have been brought up earlier and not years after several failed appeals. Now the case is in the hands of Judge Casel, who said he will make an opinion in around 56 days, and when that opinion is issued, we could see Judge Casel either deny the motion, which Willis could appeal and go through that all again, or we could see the court go forward with an evidentiary hearing to hear live testimony or even grant him a new trial right off the bat. Now next on the docket, a Norton Shore's mother convicted in one of West Michigan's most notorious child abuse cases was denied her appeal. What Shonda Vander Ark was asking and why the judge denied it is next on the docket. Now we're back in Judge Casel's courtroom. He denied the appeal of Shonda Vander Ark, the Norton Shore's mother convicted of one of the most gruesome child abuse cases in West Michigan. Vander Ark was sentenced to life in prison without the chance of parole in January 2024 for the torture and death of her 15-year-old son, Timothy Ferguson. You can watch her full trial on our streaming app right now at 1300side.com, but after this episode. Vander Ark made her appeals that she was not competent to stand trial and that she received inadequate counsel during her trial, very similar to Jeffrey Willis's hearing. And they also had the same defense attorney and longtime now retired public defender Fred Johnson. We'll do a recap of all the hearings because there were 3 and then break down Casel's opinion, starting with her hearing for incompetency in the summer of 2025.
At this point in time, the court is making a ruling that the motion for a new trial based on incompetency is denied.
This was the moment Muskegon County Circuit Judge Matthew Casel said no to a proposed new trial for Shonda Vander Ark on the basis that she was incompetent to stand trial. Vander Ark was convicted in 2023 of torturing her 15-year-old son, Timothy Ferguson, to death. Vander Ark's attorneys claim she was incompetent during the last day of testimony when she did not return to the courtroom due to mental health issues. The prosecution reacted to the judge's denial of the new trial on the competence issue.
It's just when things turn bad for Ms. Vander Ark that she conveniently gets these moments where she just can't focus and she's mentally not able to be there. And that is really not the same thing as what criminal competency is, and that came through in the judge's ruling. The competency is a different standard.
However, the judge did schedule a future hearing to see if she could be granted a new trial because of ineffective counsel.
There are a number of areas that we raised where we felt that trial counsel should have been taken maybe a different path, or called witnesses that should have been called.
The judge called for what's known as a Ginther hearing, where the court will hear evidence and testimony on whether the defendant received adequate counsel.
That is a pretty significant issue, which many times leads to reversal and a new trial if that actually can be proved to be true. I don't know that, but I think it's irresponsible of the court to simply make a decision on that based on just briefs.
Prosecutors say they plan on meeting with Vander Ark's trial attorney, Fred Johnson, and will likely call on him to testify.
Once you claim that your counsel was not effective, it opens the door for the prosecution then to be able to have those conversations and, in fact, present the outcome of those discussions in open court.
Nick Nelson, 13 on your side.
After that piece of the puzzle, it was time for the hearing on ineffective counsel in November, so a few months later. Called a Ginther hearing, the court heard evidence and testimony on whether Vander Ark received adequate counsel or not. So what happened at that hearing? Well, Vander Ark went up on the stand, but she and her attorney continued to argue that she was not feeling well. Ultimately, it was decided she did not have to testify that day, but they did have substance on the stand in the morning.
nearly a year after she was convicted of torturing and killing her son.
Count 1, charging open murder involving the death of Timothy Ferguson. We find her guilty of first-degree felony murder.
Shonda Vander Ark is arguing the attorney that represented her in that case was ineffective. On Tuesday, a Ginther hearing was first delayed because her and her attorney argued she was not well enough for the case to begin, but eventually it was ruled she was, and that trial began with the judge.
My question to you is, when these discussions you and Ms. Vander Ark, did she unequivocally say, I am not guilty of any crime?
Her attorney.
Did you guys ever have a discussion? Ms. Vander Ark, you kind of meet these elements of involuntary manslaughter.
And the prosecution.
Did you feel that she was aware about the strategy about attacking the mens rea elements?
All asking her former attorney, Fred Johnson, about the conversations revolving around her innocence or guilt, what possible outcomes could happen in the case, and if she was aware of his strategy. He answering all questions when asked.
What we talked about was she's charged with this homicide, and these are the possible outcomes a jury could legally come to, and these are what they require, and it may be and we talked about it. If we're winning the trial, what do we do?
When that was over, Vander Ark was then asked to take the stand, which she and her attorney once again argued she was not well enough.
I'm miserable. I'm lightheaded. My head is just splitting.
In the end, the judge ruled she did not have to take the stand at that time. And after a social worker and 2 law enforcement officers were questioned as well, court adjourned for the day.
Which then brought us up to March, where Vander Ark took the stand. She testified that she was terrified to take the stand during her original trial and that she has panic attacks that cause her to disassociate. She also says that there was evidence she wished her previous attorney, Johnson, would have brought to the trial, like how fast people in her family can lose weight, and also claims he didn't clearly communicate that lesser charges of involuntary manslaughter or second-degree murder would be options until the very last second. She says due to her condition, she did not bring up her concerns about Johnson and that she didn't know she could tell the court that from jail. Muskegon County mother Shonda Vander Ark testified she was terrified to take the stand during the trial that ended up in her felony murder conviction.
Stressed, panicked, scared, terrified.
But she took the stand again Friday, over 2 years since her 2023 trial, to testify that her original defense attorney was ineffective. Vander Ark was handed a life sentence for the torture and death of her 15-year-old son with special needs, Timothy Ferguson.
Are you also aware that before he passes away, you call him a dummy?
There was something said about that at trial. We all say stupid things.
She was supposed to take the stand 4 months ago, but couldn't due to a headache, and the Ginther hearing was rescheduled until Friday. Vander Ark's medical episodes were brought under scrutiny by the prosecution.
Thus, Ms. Vander Ark cannot be considered a credible historian. That's not true, but...
Vander Ark claims she suffered from panic attacks that make her disassociate.
I'm shaking. My head is totally spinning.
That also led her to dry heave on the stand during her trial. But the prosecution says Vander Ark has no medical records to corroborate the disassociation and panic attacks, instead linking the episodes to something else.
These episodes happen when you're confronted with evidence that you don't want to acknowledge or admit. Is that fair?
No, they happen when I was confronted with traumatic events.
Vander Ark says because of her state, she did not bring concerns about her previous attorney, Fred Johnson, before the court. She confirmed with the judge that she is satisfied with her current representation. Now, Judge Kaisel's opinion is long. It's 8 pages. This is already a long episode, but I'm going to put the pages on the screen and point out some of the parts of the opinion. Kaisel briefly talks about why they denied her request for a new trial based on competency, saying in part that based on testimony, it supports a finding that although the defendant may have experienced psychological and emotional distress at points during the trial, she still could understand the nature of the proceedings and was able to assist her counsel in rendering her defense. The only evidence that contradicts that finding was the testimony of the defendant herself. As discussed below, the court does not find the defendant to be a credible witness. Then Kaisel gets into the remaining matter for the court, or the effectiveness of counsel. It's quoted, "To demonstrate the denial of effective assistance of counsel, a defendant must first show that trial counsel's performance was deficient, or that the performance fell below an objective standard of reasonableness, such that counsel was not functioning as the counsel guaranteed him by the Sixth Amendment." Adding the defendant bears the burden of proof. First claim, Vander Ark alleges is that Fred Johnson was deficient by letting the trial go on knowing that she was incompetent, and that he had her sign a waiver knowing she was incompetent. He says on the next page her testimony was unconvincing. Quote, her recollection of events on the morning of December 15th was clouded by self-proclaimed lapses of consciousness that conspicuously occurred at times critical to the issue of her competency. This self-serving amnesia was substantially similar to her trial testimony when she claimed she could not remember the interactions or communications with her co-defendant that would support her criminal culpability, but could recall most other events surrounding the death of her son. To put it bluntly, she is an incredible historian. And as a side note, incredible means not credible in this context. Vander Ark also argued Johnson failed to search for or call an expert witness who could support her memory loss as legitimate, and it was a result of underlying mental illness. Kazel cites the 3 potential experts who evaluated her for separate competency and criminal responsibility exams. Quote, the reports that were generated following those examinations would not have been favorable to the defense. In fact, just the opposite was true. The reports indicated that defendants' claim of amnesia were not medically supported and appeared to be selective. He says Johnson's decision to stop his search for an expert after 3 separate physicians was not unreasonable. Next, she argues that Johnson committed a prejudicial error by failing to highlight dehydration as the cause of the victim's death. Kazel says Johnson's approach to the issue was reasonable. The opinion also states that the court disagrees with Vander Ark's argument that portions of Lieutenant Joel Hoeksema was lay opinion testimony. The court could not find that Johnson's failure to object to the testimony prejudiced Vander Ark. Finally, Vander Ark's argument on the involuntary manslaughter and intentional murder. Kazel writes that the defense's strategy culminated in Johnson telling the jury that she was guilty of involuntary manslaughter. Quote, he did not concede guilt to any intentional crime consistent with the defendant's objectives. It is only a complete concession of defendant's guilt which constitutes ineffective assistance of counsel. The opinion states that conceding to a lesser offense does not necessarily constitute ineffective counsel, neither does a concession made with the defendant's consent. Finally, Kazel finishes with, quote, the evidence of defendant's guilt in this case was overwhelming. Assuming arguendo that Mr. Johnson's performance was deficient, this court cannot find that there is a reasonable probability the correction of those errors would have resulted in a different outcome. And that's the end of that. And like we will see with Willis, Vander Ark could take several more routes for appeals in more standard terms. So we'll just have to wait and see. Thanks for joining me on this episode of On the Docket. We have more episodes streaming now, taking you into the courtroom for the latest updates and deep dives on crime in and around West Michigan. In the meantime, we'll bring you the latest on crime in court, both on air and online at thirdtonyourside.com. And when breaking news affects you and your community, we stream live with what you need to know right when you need to know. We'll see you next time with updates on What's on the Docket.